I appreciate everything that I've heard tonight. I know that this is a sensitive.
I need your name.
Chase Hendricks.
Chase?
Yeah. 25 North, 2nd East, Rexburg, Idaho. So, I appreciate everything that's kind of been discussed here tonight. I know that this is a sensitive area that a lot of people hold near and dear to their hearts. Island Park's a wonderful place. I know that's why we're all here, and we all choose to enjoy the benefits. At some point, I hope everyone realizes that the cabin that you're in and that the homes that you enjoy and the things that you enjoy, someone else opposed, you come. And, that's par for the course in America. There's all sorts of issues that, go on that people just do not like to see change. And I can appreciate that and understand that. The problem is when a plat satisfies the requirements of the zoning code, the comprehensive plan, and some of the other requirements, the commission's kind of in a bind. And I think it's unfair to throw that at the feet of staff who they don't make enough to earn any kind of abuse like that, because they just have to look at the code, judge the application against those requirements in their code, and that's all they can do. Anything else is a taking, which means that government's saying you can't do with your property what they originally said you could. So I lost my notes here. I just wanted to touch upon a few things that everyone's kind of talked about. So regarding fences, that's on the plat and the covenant. Any kind of requirement that the commission wants to see out the fencing, we're happy to write those into the covenant. That's not an issue at all. Along with that, wells and sewer, there's been a lot of discussion on that. This is a preliminary plat. It means it gives you the bones of what we're trying to do here. Now, if you see a mistake or if you want to see any kind of change on that, we're happy to fix that before final plat, including the wells, and sewer and septics. I was trying to go back through everything, and I don't know where people are getting the septics are going to approved. This whole entire subdivision's getting hooked up to the county system, and so septics are a non-issue.
Well, yeah, you have references to septics.
You do. There's a conflict. So it does say that we're going to be connected to the main septic systems in the city or the county, but within there, it's slipped in there, and somebody hasn't found it says septic. There.
Oh,
That's in that one.
well, yeah. So that's not correct.
Just a mistake.
It's just a mistake. I want everyone to see it. Plus, the county's not the enforcing agency for septics. That's all governed by DEQ and IDWR. Same thing with the water rights. That's something kind of outside the realm of the county. But this subdivision plans on complying with all requirements of those entities and all those agencies, including any neighboring uses. Idaho code is such that you cannot impact the water usage of your neighbor. And if you do, you pay the consequences. This development, only intends to comply with that. The wildlife and water studies, I think I kept hearing about that nutrient pathogen study. That study was done to see if septics were even allowed. After we got that and in discussions with the county, we realized that it had to be hooked up to the county system. So that's what they've done. That's what they have agreed to do in the future. And here again, there's this idea that this has to be a fully cooked. We've complied with every requirement and discussed with staff over a 9 month to a year period to try to comply with all those requirements. that the answer is not just to scuttle the whole project and say, no, we don't like it as the neighboring uses, and you can't do with your property what we originally said under our code you could. Rather, there are options to add any kind of conditions or requirements that development agreement's a living document. It's not finalized until it gets completely through the process with the final plat that is planned to meeting those considerations. And so, by all means, we're asking for an approval on the preliminary plat with any conditions that the board may choose to do, any plans added or any kind of requirements that would make you feel like it matches the requirements. I guess, I heard a lot about the comprehensive plan. I was looking through the comprehensive plan. The land use compatibility limits density to approximately 1 unit per 2 acres. This is stockpiling and putting it over and above the zoning requirements and open space requirements. So I just don't know. It was interesting that no one really referenced what part of the comprehensive plan that they think it violates, because setting aside over 30% of the land, mapping and avoiding delineated wetlands is shown on the wetland sheet, which we providing a complete drainage and road plan, Indian County and DEQ standards, an ongoing obligation, I should add. Meeting an open space ownership. I understand that's a scenic quality and visual sensitivity area, but that doesn't mean you can't do anything on there. And I think that's what the public would like to see, is just to put that, into grasslands. So you have that option, but you have to pay for it. You have to pay for that ground. The only way to do that is through some kind of government pay piece, putting that on the property taxes for people to pay for. It includes the design features of natural vegetation buffers and limited road cuts to minimize visual impact. We're trying to maintain low structure density and avoid ridge-top kind of developments. It also has a transportation plan that has internal street networks with 2 points of ingress and egress, despite having the public may not be aware of some of those issues that have been discussed with county staff for some time. We really are trying to place any kind of excessive traffic on the logo. I know how busy the freeway is out there, or the state highway. So we're doing everything that we can to protect against that from happening. And more than willing, if you see something deficient, to have it approved subject to whatever condition you think, or whatever studies that would be required along those lines. And then I don't know what's version of those covenants that you got, but there was a lot of blood, sweat, and toil that kind of went over the wildlife and how the best to have that arranged. That's a difficulty for all subdivisions in that. We want to not prohibit wildlife and all the things. That's why everyone loves coming up here, stabbing animals. But that would be a detriment to anyone that builds them. So by all means, those covenants are an open book. If you see or think of requirements that would help with wildlife, then please add them. We have no problem adding any kind of covenants. But, just going through the subdivision plans, there's the requirement for this zone is no more than 20 dwellings per 100 acres. Well, we're doing 32 lots on 160 acres. So the density is way under the requirement. Our acres are over the 1 acre minimums. The open space requirement requires 65. We're producing 70%, including active use space, trailhead, and picnic filters. We are doing exactly what the code requires for clustering, hooking up the sewer, and let's dispel that rumor right now that it won't be hooked up to sewer. The water issues are interesting, and I heard there was a lot of, water's an issue in the state. the legislature just passed a new statute on community wells where that is available, that you can get domestic uses for community wells. And here again, if you have to buy water rights to be will, but I don't think we'll have to with either a community well or individual wells. That's what everyone else is on. And in fact, I wondered if it wouldn't help with some of the historic flooding that was discussed out on that side of the area. So, again, the water quality protection, we've provided a study along those lines, and wetland buffers. We're setting up back 100 feet more than the 75 requirement in the code. Wildlife protection, 48.12 contiguous acres of open space with habitat fencing, bear protocols, including the CCRs, and then the road standards. So as we've worked through this, the ordinance and the comprehensive plan, we've really tried to pattern this on what would make sense for this area. And I know everyone would rather have it be, ground schools and shrub ground for, the rest of eternity, but that is a designated zone in an ordinance that allows development. And so that's what we have proposed. We try to match those ordinances and the requirements and your development code as best we can. We're more than willing to increase those if there's a particular point. So just approve the preliminary plat subject to any conditions that the planning and zoning commission would have. I might not be the best for questions, but I can stand for questions.
Yeah. I want to just give some information. You said that there was nobody that, showed a reference to what they were talking about in the comp plan. But I have it on 4 different speakers, and then I took notes on every speaker. Policy 11, 12, 14, 17, and 18 were mentioned by the speakers to refer to what they had in the top plan that made these considered.
So, the ones I heard, and it is kind of hard.
12, 14, 17.
There is a 12.
Also, you talked about perhaps the wells would drop some of the water problem, but it's also stated in the development code and by the water resources people that one of the things they don't want to have done is to diminish the wetlands that are already currently in existence.
Exactly. So it feels like you're damned if you do, damned if you don't. I'm trying to see what 12, 14.
I didn't bring my list today, but I should. I've also noticed it in many of the letters that were turned in from all sites.
And I understand that. The comprehensive plan is an overall, it's a policy document to guide the county. It's not a prescriptive code. It's something to say, this is what we want our county to be. We want it to be concerned about scenic byways. And we want it to be concerned about wildlife. And I think that the proposal meets or exceeds any of those requirements. I didn't take notes on the few that I did, but I couldn't speak to exactly which ones those were. I didn't get a good sense of what they were saying. Just besides an opinion, they don't think it would meet.
So they actually cited this.
Yeah, and I appreciate that. I just didn't hear how they thought that this did not meet the objective.
I saw that concerned me somewhat is that in a stormwater provision plan, no irrigation ditch was filtered. That was also some of the speakers. And also they mentioned that and I actually put 280 page here, this nasty ass document, pardon my French. And that was today, after I got the rest of the stuff. And it asks about historical significant sites, and it's stated in that document that there are none. But also there's a little box in there you're supposed to check what your sources were for that information. That has not been checked.
What was the title of that?
It's not just the,
It's the stormwater prevention.
Almost.
Lake talks.
Our engineer will talk to those issues.
Chairman, question. Mr. Hendricks, are you an attorney now?
I am. For my sense.
Yeah. You're probably way more familiar with this language. Well, in our comprehensive plan, we are told we shall comply with that. I think it's how Nelson explained that. How would you interpret that?
Well, the comprehensive plan is somewhat of an idealized version of how you would like to see the county develop. It is not a prescriptive plan. It simply has a look at the case law. So the idea is that you highlight those things that you care about and say these matter to us, and then you weigh that against the requirements of the development code. It is. I do see why people are upset about that comprehensive plan. I think it's from 2008, maybe with a few adjustments. Things have changed a lot since then. I understand that. But the idea is that you can't hold one developer hostage for that lack of, future planning. It's an important document. I won't discount that. But those requirements, I guess I just disagree that those issues about scenic beauty and wildlife protections and all those requirements in the comprehensive plan, we haven't done everything that we possibly can to adjust for those, and are willing to adjust further if that is a specific requirement that the commission, the board of county commissioners require them. So they're happy to comply with whatever you want or want.
Anybody else have a? Yeah.
In our training as members of this commission, we recently went through a session regarding comprehensive plan and the development code, and that the development code does support the comprehensive plan and vice versa. And it says that it shall. So what's in the comprehensive plan is linked to what's in the development code. And guys, we don't show up here once a month and make decisions without having some training and knowing what I feel like the bugs on the chair at school because we are smart enough to know that we don't know what we need. And I'm sorry that I'm tired. But we don't do this lightly. And lost the train. I had this thing that we can take comprehensive plan, point by point, the master plan. They have to this, or you've got to rid this. And we do this. I've been doing it now for 3 years. And so we do have a clue what we're supposed to do. We know we had a session recently about master planning and how it applies to county. And I've had these documents since last week. And I did read them. I admit I didn't read all 280 pages of this because the last 100 or so are boilerplate. It's just.
I didn't read it either, Kathy.
What?
I didn't read it either.
It's too good. No, I had more than 6 hours to prepare. I spent the last 3 days doing this. I don't come here lightly, and I don't come here uneducated without knowing a little bit about this. Oh, I'm sorry, but we got this staff report last week. Friday, I believe. Maybe it was late Friday. But I had plenty of time to go over it. And to think that you think we come here lightly without knowing what we're doing, I'm sorry, that's to me.
There is another spot on the, it's a stormwater plan, but I think there was a go there. And, it says that the Hendricks Fork outlet is Meadow Creek. And, you don't want that in there.
Yeah.
So you need to print.
We're happy to do that.
Two separate.
I did look back here and that the policy 14 density cluster agricultural land preservation and open space. My earlier comments have tried to express how we've tried to plan around that requirement of comprehensive plan. Policy 10.1, water resources. Again, we want to protect all neighboring uses, ditches. That we have no intention of. Sorry, this thing doesn't work very good. I feel like it will.
Talk into it.
I got it.
I'll get some cooties.
Put your lip on it.
Yeah. So our intention is to completely comply with all of Idaho water rights requirements, any senior uses, mitigation, etc. So we totally anticipate and plan to comply with those IDWR requirements. Policy 11, I'd be curious to see where you've had a better cooked out policy for wildlife up here. I've known of the issues here, and I'm sure the commission knows, but maybe not. By all means, if you're seeing something that could be a requirement of those covenants, fine. Those are a living document until the final signature and recording. So we're happy to change any of those requirements. So if you think it better fits the comprehensive plan, the guiding principles. But and my point is with the comprehensive plan, it's a policy document that will steer the commission in those conditions, not a prohibitive document that says, oh, you don't, our opinion is that you didn't comply with this one word, and so it's a done event.
It's good that you want to give us it.
I got something to say, but real quick.
We're not dealing with talk too.
He's almost got a store. One more thing I've come things too. I just went off about what. I spent the last 4 years with wetland. I spent the last 4 years with wetland. There was some things said tonight that said the whole property was wetland. It is not. If you want to look up some background, read the second case. The Supreme Court case. I think it was January of 23 that it was determined, and our environmental specialists performed our wetland study testified before the Supreme Court, and the case was centered around a couple that was trying to build a property in near Boise, and the Army Corps was stop order on their project. They sued. Well, of course, anyway, no Supreme Court. And what came out of that decision was that weapons of the United States, Army Corps was originally, I better not say too much, but it governs most of our large bodies of waters and rivers, streams, and stuff like that. And so it's hard to apply to other parcels and stuff. What came out of that case was that isolated pockets of water separated from the distributor, the feeder, let's say, not necessarily jurisdiction of the Army Corps and EPA. We signed a preliminary jurisdictional determination on our property, and it defined, we accepted responsibility for that report and the defined wetlands of that report. It was agreed to by the Army Corps of Engineers, the United States EPA. So that is the law. You can stand up here and show maps and this and that, and say, well, there's wetlands here, there's wetlands here, but this is the real deal. And I'm very sensitive to that, obviously. Um, you don't want to mess with that, okay? We respect those. Whenever majority of the wetlands were up in the northeast section of our property, and those are all included in our wildlife reserve. So I'd say right now, I'd say it's going to be 90% plus weapons on our subdivision in our wildlife reserve. Careful at anything. Okay? Except ranch that controls and owns that get that right, that's it. They can make it maintenance, they can dig it out, they can do it. I can't do that. They have to do that. I'm not gonna touch those facilities. But the smaller one that's in the front of our property, we'll go back, as Mr. Clough said, we'll get a permit. This is a preliminary plat. We're not done here. We get a preliminary plat, we've got to go back here before we get a permit. Every time we cross any wetland, and the wetland that's in the body of our development is 3 foot wide. We can cross it 2 or 3 times. We'll get a permit. We won't even break ground until we have those permits in place. If you want to make them a condition of final plat, we're fine with that. Those are all things that are going to happen. This is preliminary plat. Without preliminary plat approval, we can't go forward. We can't finish this thing. We can't answer a lot of these questions and do the hard work. And you'll have another shot at them to deny, we can't get that done. But this is it's a lot of work. It's a lot of time, a lot of money, a lot of activation, and a lot of interest. And somehow we have to move this process along. Mr. Gill, go ahead.
A couple of questions that you had during this. Talk about fences and the down in the winter, and I know they do that. Are you planning this in the year round? Are people live there year round?
If they want to, they can. Yeah, I probably not though. Just like a lot of types of homes and Georgia restaurant, I
just wondered because if you're going to people there year round, they'll probably come in and go snowmobiling in the winter. They could just take off from there and go out on the flat.
So it's my intent.
No, you can't speak. I'm sorry. No,
Robert's rules, correct?
no. This is a public hearing at this point. You don't.
Hearing
You're
is
not
Robert's
speaking.
rules. Point of order, please.
No,
You may get to rebut.
Sorry, but no.
Allegations here, now. Point
no,
of order.
no.
It's a legitimate right
Not in
question.
public hearing, I'm sorry.
That question. Point of order. I want to know if we can rebut these allegations.
Be gentle. No, be gentle. Snowmobiles.
Oh,
So,
here's my plan. Snowmobile season out there is crazy. People go all over. They jump across the highway. They're all over the place. In our subdivision, it's fine that people will be able to drive their snowmobiles on their property, and they'll be able to exit their property to the north, to the state ground. Fences are down, but we're gonna tell them not to cross over their neighbor's property. We're not gonna have crazy stuff going all over the place. We're gonna stick to roads. We're gonna stick to roads. Oh wait. So my idea is not that our list if where they want to. We'll stay out the road, or if they want to, it's the property.
I guess I want to talk to them more. I guess